All right. I'd like to welcome everyone to today's webinar, Access to Justice and the Future of Class Actions After Recent Reforms. Before we begin, I will say that the webinars going around Australia, various locations, and I think also I think we've also got some distinguished attendees from across the ditch in New Zealand. But wherever you are, I think you're probably in an area that was occupied by the traditional inhabitants, and in relation to Monash, that would be the Kulin Nation. So we pay our respects to them and to their elders past and present. So thank you for attending. We have some distinguished speakers today who I'll introduce in more detail in a minute. Professor Peta Spender, Jason Betts and Julian Schimmel. But before we begin, I'll just talk briefly about the general overall concept of access to justice, and in particular, I'll just mention the research that we have recently done on the general concept of access to civil justice, published in the Adelaide Law Review, and assisted by a research donation which contributed to some of the costs of doing that research, a generous research donation from Maurice Blackburn, and that research was done by myself, Matt Nichol of Central Queensland University, and Andrew Coleman of Swinburne University. So I was just going to mention some of the interesting findings from that overall access to civil justice. Now today we'll be mainly talking about class actions, which of course is a subset of access to civil justice, and an important subset of access to civil justice. But in terms of the findings overall of the overall survey, some of the interesting things, what were the most common problems for legal problems for average Australians, and we found that coming in first was in fact employment law problems, which was interesting. Secondly, it was family law problems, and in third place was money, debt or insolvency problems. And I guess perhaps that's not so surprising for ordinary people, ordinary Australians. The first two, I guess, in terms of the one of the significant legal relationships in most people's lives, one is in fact with their employer, and the other is with their significant other. So those are legal relationships, although we don't always think of them as such, but the law does get involved, and particularly if they end, the law certainly gets involved. So they were some of the findings in relation to the most common legal problems, and obviously the third one, money, debt, insolvency, cash flow issues for people and for their small businesses and for their livelihoods and so on, and debt and so on. Some other interesting findings. I was just going to mention some of the highest impact legal problems felt by average Australians in terms of the survey that we did across Australia. The highest impact was a claim or a problem in relation to total and permanent disablement, which was found to have a very high impact on people's lives. And the second one, which was a little bit surprising, was actually defamation, libel, slander, and other people defaming people, besmirching their good reputation. And I think probably the internet, social media, probably has something that comes in there a little bit as well. What were the most popular sorts of advice people sought in terms of access to justice? Well, the first one was actually just advice from lawyers, just general advice. Where do I stand? The second most common was representation in a negotiation. The third was the drawing of a document, legal document, perhaps a will. And the fourth, somewhat associated with that, drawing of a letter of demand. And it was only number 5, I think, came in the actual commencement of proceedings, came in as the 5th most popular legal service. But one of the questions we asked was, is access to justice increasing or not increasing? And obviously this survey was done before some of the recent changes. And the finding was that the perception was that it had increased somewhat in the previous 20 years. And what were the main factors in that? Well, the two main factors that seemed to come out was, one was the the introduction of no win, no charge, no win, no fee type legal fee agreements came in as the number one. Number two was actually more information from government. And again, I think the technological change is a factor there, quite likely. I don't know how many people can remember 25 years ago trying to get information from government about legal issues, but you'd have to get on the phone, ring up a department, you'd have to go to the library, you'd have to go to the Citizens Advice Bureau, you have to get a brochure or something. We can't even remember it now. It's hard to even believe that that's how it was, but that's how it was. Whereas now it's all at your fingertips. So I guess information from government has helped in terms of people's access to knowing about their legal rights and so on as well. So there are just some general comments about the breadth of access to justice. I suppose I should, given that today we'll be talking a fair bit about federal legislation and possibly making some criticisms of same, access to justice is a very broad concept. So perhaps I should, in fairness, also, I guess, mention that it probably encompasses some of the things that are going through the state parliament as well. The ancient writ of habeas corpus, the right not to be detained by the state arbitrarily and so on without access to the courts. That's obviously something that's being discussed at the moment and perhaps causing a bit of a stir, and has been commented on by a number of people. So I mentioned that, I guess, as something that is also an aspect of this broad concept of access to justice. So having talked about all those types of access to justice and those areas of access to justice, we'll now perhaps move in focus on a particular subset of access to justice, being in the area of class actions, and the recent legislation and the foreshadowed legislation in relation to class actions. Class actions are a very important area of access to justice, and so I will now introduce my speakers, and the first speaker is Professor Peta Spender of the Australian National University. Professor Spender is an emeritus professor and a fellow of the Australian Academy of Law, a presidential member of the ACT Civil and Administrative Tribunal, and formerly appointed to the ACT Court Joint Rules Advisory Committee. Her research interests include corporations and financial markets law and regulation, as well as class actions and collective redress. And she publishes widely in those areas. Professor Spender has been cited by the Australian High Court and in amicus briefs filed in the US Supreme Court. For many years, she's also explored the role of women in corporations, including the issue of gender quotas for corporate boards. So I now give you Professor Spender, who will address some of these interesting issues, and we look forward now to her insights. Professor Spender.
So thank you very much. I'll just share my screen. Voila. Can you see that? Can you see my screen?
Yep.
Fantastic. Okay. So thank you very much for the invitation to talk about this. It's a fascinating topic, always fascinating. What I'm particularly interested in is the broader issue, some of the broader questions about what I refer to as the regulation of class actions. So what we have, and the question I'm asking myself is how we can design class actions so they operate as what I call a regulatory node, and that allows them to check corporate and government power in particular ways. And the question is what effect the recent reforms have had on this endeavour. So the background of this is we've had class actions in Australia for 30 years. So we've had an opportunity to look not only at what's occurred in the past, we can look prospectively, but we also have quite a few state-based class action regimes. So we've got some good competition between the jurisdictions, the state and the federal jurisdictions for class actions. And that includes some rule variations as well. So, for example, the group costs orders under the Victorian regime is a really important difference between the federal and the state jurisdiction. So if we're going to think about how to design an optimal class action regime, we have to deal with many unknown unknowns. And one of them in particular is whether it delivers justice. And I differentiate between the subjective assessment of justice, which Michael has dealt with in his article, and I'll come back to, and the actual delivery of justice. That's almost impossible to measure. So we'll come back to that. So when we're designing an optimal class action regime, we have to think about how it differs between individual and group proceedings. And I don't need to tell you that the reason class actions were created in the first instance is to overcome structural barriers to individual litigation, such as psychological, social, economic, particularly costs. But the engineering of a class action is really quite different. It creates really quite different incentives to commence proceedings, for example. So when we think about individual litigation, we think about individuals seeking redress, whereas in a class action, it's very likely to be initiated by lawyers and funders who are thinking about looking for opportunities, sometimes I think through adversity. But so that means that the incentives to commence are really different, and the viability of class actions is different. So if you've got a large, a claim that has a big group who have small claims, that you have to think about the commercial viability of the class action. Always the case too in individual litigation, it just operates differently. The viability questions are different in a class actions. So the way that I see class actions is as a regulatory node. Now, the way that I imagine the regulatory node is really quite different to the way that lawyers think about regulatory nodes, regulation, because lawyers tend to think of regulation as something that restrains particularly individual choices. I'm actually using the term the way that social scientists use it, because I'm thinking about regulation as a pluralistic concept. I'm thinking about how it controls behaviour, and it does it through, control is a really important part of it, but it does it through a range of mechanisms. And you can see that on the slide: monitoring, compliance, enforcement, standard setting. This is in the context of what the social scientists call regulatory capitalism. And the important thing about regulatory capitalism is that the control of negative externalities works through social regulation. Okay, so it's a bigger concept than regulation as lawyers know. And the regulatory node where class actions operate work within a matrix or a network of actors. And what they're doing, what we're interested in them doing, is delivering what Peta Spender calls the public principles of conduct. This is, you probably are aware of these regulatory theorists. They're all Levy-Fur, Braithwaite, Drahos, Christine Parker. They're all working on this concept of the pluralistic, if you like, regulation. So they generate this activity in order to restrain actors through public principles of conduct. And I'll come to the relevant ones that I think operate in a moment, the relevant public principles of conduct. So to give you an example of how a regulatory node might work, take, for example, Crown Resorts. You've got a group of people and actors doing various things. You've got the Bergen and the Finkelstein inquiry into the licensing, the casino. You've got questions of money laundering. You've got criminal proceedings that took place against the employees in China. And you've got also these two class actions, at least two class actions that have been commenced. One in the federal court, which is just about to have settlement approved, and the other one in Victoria, where you've got potential benefit of the group costs order. But when you're talking about, so many actors operating together to restrain conduct, you've also potentially got ASIC investigation, but I'm not sure where that's up to. So if anybody knows, please tell me. But because you're dealing with a market instrument, you have to think about what Dross calls the tragedy of commodification. And that's the problem about what economists call rent seeking. But really what it comes down to here is impermissible rent extraction, getting more than they're entitled to. And that's become part of the narrative of the recent reforms, particularly on the part of litigation funds. They're extracting excess rent, and therefore we have to restrain that. Okay, so these are the relevant principles of conduct that operate in the class action system. These are well traversed. We understand these very, very clearly. The one that probably has the greatest resonance, I think, is deterrence, the idea that class actions actively deter. And we can see that, for example, in the robo-debt litigation. We might sort of confine how we see its deterrent effect as having occurred. Well, for example, you might say that the federal government is going to be very careful about using automated decision-making when they're dealing with mass transaction asserting debt liability. You might even confine it that much, but it does look a little bit like deterrence. The problem is, of course, is that sometimes activity can overly deter. And that's the argument that's put by the opponents of class actions. And there's also questions about the disproportionality of the resources that go to the civil justice system compared to the compensation. That's part of what I call the 70% bill. But the regulatory note contemplates that there will be other actors in the space. So you've got conventional regulators like ASIC. ASIC's important, and ASIC recognises its division of labour with class actions. And I've got the ALRC reference there. I've got references at the end of my slides that I'll just quickly flick through to at the end so you can see them. You've also got institutions, because courts are doing some very heavy lifting in this space, and we have to think about what they're doing. But anyway, the Hayne Royal Commission demonstrates the need for what Gunningham calls surrogate regulators working in this space. So let's think carefully about what the class action might be achieving in that capacity. So let's think about what's been happening. This is a slide that's just designed to gee whiz, this is the amount of activity that's been occurring over the last 2 years, just in relation, and it's not even all of it. There's been massive amount of activity. And I just note the 70% bill, that's what I call the 70% bill, that'll be talked about in much greater length in a moment. What I'm concerned about is the process of class action rule formation, because what we need is a systematic creative design of the node. But instead, we've got this, well, I think actually we've just got this terrible, it's just messy. The policy formation is messy. There's lots of strident views, but there's no systematic creative design of the node. And so this activity that's been occurring recently that I refer to as the hyperlexic churn, there's been this, what I call a cacophony of consultations. There's a huge amount of activity. The consultation seems to be window dressing, and it, in some respects, concerns me because it falsely legitimates the process that is occurring. So there's currently a consultation that's occurring regarding the 70% bill. Now, the problem with the way in which the lawmaking is occurring is that you've got the executive using transitory law, particularly short-term legislative instruments and legislative instrument. You've got this churn of activity through Parliament. You've got it's rushed and it's bifurcated along ideological lines. So you've got the reports coming from sources like the PJC, but you can determine the outcome almost before they're published. You know what's going to happen because they're going to frequently do what they were going to do anyway. And I exempt the ALRC from that process. The premise of the other thing that's really important is the interest group activity. We know interest group occurs with lawmaking all the time, nothing unusual about that. This one's particularly bifurcated between the business groups and particularly boards and the litigation funders and plaintiff lawyers. Each of them are very, very highly persuasive in their own ways. Now, the question is how that bifurcation goes to in other areas. I think it sort of moves a little bit into corporate governance, because there's those questions, for example, about the way that there's divergent interest between the board and investors. There's nothing unusual about that. It's ever been thus, but there's perhaps an increasing divergence of interest. So investors might be much more interested in class actions, and I've never seen a board yet that was interested in a class action. So there's a divergence of interest. It's been reflected perhaps more radically in shareholder interest in the ESG area and climate change activism. So there's this divergence that are occurring, and I'll come back to that for the purposes of class actions in a moment. So there's interest group lobbying that's occurring, of course, in Victoria. The group costs orders arose out of that. I know the Law Reform Commission did a report in 2008, but there's lots of activity there too on the part of people on the other side of the ledger. So the other thing is about the premise of the policy debate. The premise is the gouging by litigation funders, and what I call the Letho model of litigation funders. It's based on serious misconduct, but it's a narrative. It's a narrative about what participants are doing. And I've got the reference to the Banksia litigation at the end of my slides. The other thing is judicial lawmaking. We had this problem for quite a long time about the cases on the the substantive issues just being too sparse, because there were, settlements were occurring at a fast rate. We had too few cases. That's starting to change, which I'm pleased about, because it means that we'll actually, it might be that with all this activity we find that causation can't be established. That's a good outcome in my view. But in the meantime, we've got this judicial reticence about, particularly appellate courts and the High Court in particular, being a bit concerned about delving too much into the marketisation of claims. They're a bit concerned about business models, and that you can see that in the High Court decision in Brewster. They don't really want to, they don't see it as part of the judicial role to be involved in some of those broader questions about the commercial viability of claims. So the federal court's more pragmatic. The Wigman's case demonstrates the High Court might be moving a little bit on this as well, so more to come. We also need to think about the appropriate allocation of resources to the civil justice system. So we have to address the questions about efficiency and class action processes. Now, this is the messy law that we've arrived at. We've got this problem about reduced transparency in financial markets, and that's the changes to the continuous disclosure laws. I'll come back to that, what the consequences are, and I think Julian might say something about it too. We've got this funding model that's squeezed into the managed investment scheme. It was never intended to do that, and there's problems about how it fits. We've got the Australian Financial Services Licence. I advocated for that because I really wanted there to be more addressing of conflicts of interest in many areas, particularly I think as between litigation funders and lawyers. But it doesn't exactly fit because it's a special beast of the class action. So we've got to work a lot on that model. We've got confusion about common fund orders. The 70% bill attempts to address that. Well, sorry, it restrains them. So we probably need an express power. I think those orders are really beneficial, but I'll allow the other speakers to come back, or sorry, I'll invite the other speakers to come back to that. We've also got this issue about the heavy lifting of the courts. There's more opportunities for them to use contradictors and litigation funders. So, litigation fee assessors. So that's something that's beneficial. Moving on, there's been a discussion about whether the 70% bill is unconstitutional. It looks very tricky, and I'll come back to that at the time. Okay, there's a question about the proportionality. Does proportionality assist? This is something that I think is very interesting because there's a lot of movement on proportionality, and in particular, the question about whether there's a disproportionate step in litigation can be restrained. So we've got this High Court jurisprudence, particularly coming from ANU and Aon, UBS and Tyne, dealing with the question about whether you can restrain disproportionate steps. This might be a source of some, sort of good jurisprudence. At the moment, it's working on the edges, though, it's dealing more with more dispositive applications. I'm not sure if it will work so well in the middle with sophisticated actors. So, and there's also a question about how proportionality is conceptualised, particularly in a context where, as I say on the side, it's not buttressed by a thick set of rights and obligations like you'd find in a Bill of Rights. And there might be some testing of that with the Queensland Bill of Rights in the climate change litigation. So what do we need to preserve in class actions in order to make sure that it fulfills the public principles of conduct? The first thing I think we've got to think about is the substantive question, the transparency in the financial markets. And I, in various submissions that I've made while I was still making submissions, I talked about the difference between the retail investors and the institutional investors, or the big investors in the market. We need to maintain transparency because retail investors they're increasing in number. They're increasing in particular categories, what they call Generation Z and older women investors, but they're more dependent upon formal sources of information. So we need to protect them. The institutionals can look after themselves very, very effectively. So those transparency mechanisms are really important in my view. The next thing is that we've got to preserve is the open class, because the open class is jeopardised by the 70% bill. And naturally, there's a longer tail of retail investors. 2 minutes, okay. Yeah, so we have to be careful about maintaining open class to allow the retail investors to join in. So that's a critical access to justice issue. The third thing is the viability of class actions, which I've talked about already. But the other thing I think that's really very interesting and important is the question about class action and discourse. And that's the question, I mean, it's characterised sometimes as lawfare, but we really have to think about how class actions channel grievances into a contestability framework. This is based a lot on Philip Pettit's work. And some of that question about feeling of powerlessness when they're dealing with large institutions like corporates and government, but also that question about the public desire for confrontation. So even if litigation fails, it creates a loop of public discourse. Now, I'll commend, one of the things I think is that Australians are very interested in class actions. So I think they're much more interested than people recognise, and this is borne out by Michael's work. He didn't actually refer to it. Sorry, I'll just dismiss because my 20 minutes are up. I'll just say that I commend to you Michael's work, because he says that people believe that there's been an increase in access to justice, and that's in part because of their belief in class actions and litigation funding. So that's empirically established that there is an interest in this and being able to contest decisions. Okay, so it's still a question about whether justice is achieved. What do we do from here? More publicly available information. We need the ALRC. We need to deliberate from the ALRC report, and we need creative approaches. I'll just quickly flick up. Thank you. The references and books, cases, and you can see that you can, if you want to look up any of this, you can look those up. So thank you. Done.
Thanks, Peter. And we'll be taking questions at the end through the Q&A function. So we'll do that at the end. And so we'll move on now to our second speaker, Jason Betts, who is a partner at Herbert Smith Freehills. Jason is an Australian disputes partner and is the global head of class actions with Herbert Smith Freehills lawyers. and he specialises in class action litigation and major regulatory investigations. He's one of Australia's leading class action corporate regulatory and product liability specialists with over 20 years experience in litigation. Has defended some of the largest class actions, including shareholder claims, as well as regulatory investigations and prosecutions, and corporate distress liability issues in the Australian market. And Jason acted also in the seminal 2006 Foster decision, which established the modern law on third-party litigation funding. Without that case, we probably wouldn't even be here today. I thank you, Jason, for making yourself available, and I'll hand over to you now.
Thank you very much, and to Monash University for the opportunity to join the panel. There were four topics I briefly wanted to discuss under the rubric of the regulation of class actions. One is to discuss the state of the market that has arguably been the reason for the renewed or ongoing interest in increased and different regulation. The second is to discuss some of the doctrinal challenges that the growth in class actions has given rise to, because they make for very interesting moments of comparison over the last 30 years between where we started and where we are now. Thirdly, to talk about some possible solutions, trying to wade through the morass of ideas and regulatory solutions that are presently on the smorgasbord. And lastly, to talk about the future and briefly touching on the 70% proposed 70% law. And I'll be brief on each of those because each of them in themselves could occupy a discussion of a panel of this nature. And I also note that our attendees include extremely experienced practitioners who all have their own journeys, some of them much more advanced than mine in these spaces. So firstly, dealing with the state of the market, it is sometimes even controversial in class actions to describe the growth of the Australian class action environment as significant, but statistically at least we have seen growth over the last period of time. In the last 4 years, for example, we are averaging about 60 class actions per year. That's 2 or 3 times the 30-year average, which is closer to 25 actions a year. In the 12 months leading up to March this year, we saw close to 70 actions filed, and that was the largest in any yearly period in the 30-year history of Australian class actions. Just prior to the introduction of the new funding regulatory reforms, 11 class actions were filed in 48 hours, trying to get the benefit of the grandfathering for those pre-existing actions when the new legislation was adopted. States and federal court compete, my word, not theirs, for class action filings. And while Supreme Courts were traditionally not a popular jurisdiction for class actions, that's changed radically. And as has the split between the New South Wales Supreme Court and the Victorian Supreme Court, just to single those two out. At the moment, we have seen 43 cases commenced in the New South Wales Supreme Court and 40 in the Victorian Supreme Court over the last 4 years. That sounds about even, but it's only as a result of a 22-5 split in favour of the Victorian Supreme Court in the last 12-month period, no doubt, in part attributable to the introduction of contingency fees in that jurisdiction. Shareholder class actions remain an important and perhaps dominating species of class action litigation, but in reality, they're about 20% of the class actions that are filed nationally. So that is a snapshot of what might be regarded as significant growth. About 35% of all class actions ever filed in Australia have occurred in the last 6 years. By frequency of filing, we're not breaking the bank compared to Canada and the United States, but these are significant claims and the growth has been meaningful. Funding, which I won't address in any detail except to discuss the legislative changes that are proposed at the moment, is an inexorable part of the story of class actions. And we've seen about 1/3 of all class actions in the last 30 years funded. But in the last 4 years, that percentage is 60%. So the funding market has grown and diversified. It is probably the leading we are probably the leading jurisdiction for third-party funding in the world. Now, that growth, if I can call it that for today's purposes, has challenged our class action system. It was not written 30 years ago to accommodate some of what we are seeing today. Those doctrinal challenges, which I will just survey one or two of to turn to my second topic, are plentiful. We've seen the rise of multiplicity and the notion of competing class actions. We've seen the creation of and possibly the temporary death of a new mechanism for funding class actions in the form of common fund orders. We've seen difficulties with parties and users of class action mechanisms getting finality as to who is in the class and how to settle them with finality due to the changing law around the permissibility of class closure orders. We've seen very novel and interesting questions emerge in recent years about whether our class action mechanism can be used for those who purely bring foreign law claims. And most recently, and more thematically, we've seen a very stubborn focus, possibly appropriately so, on the proportionality of recovery in class action litigation versus their cost of prosecution. Now, that's often through the lens of whether funders are extracting too much of this from the system. I don't want to look at it through that lens. I'm a defence lawyer, so much of what I say around that you would have to take with a grain of salt. But I do want to look at it from the question of class actions, proportionality of recovery versus cost, and how efficient they are as a vehicle for achieving their goals at the time that the legislation was created 30 years ago. Let me just deal with one of those doctrinal challenges momentarily, which is the challenge to our doctrines, traditional doctrines created by multiplicity of class actions. We have seen this emerge as possibly one of the most significant issues in class actions in recent years. Famously, when competing class actions were commenced in the federal court against Get Swift in recent years, Justice Lee created a mechanism for resolving them through what became known as a carriage motion, which was a process of determining which claim or claims should proceed and permanently staying the others. And many cases since Get Swift have grappled with how that carriage motion should be properly executed. And in fact, the High Court has now considered that matter in Wigmans and AMP, a case that I was involved with and some of our audience were just as involved in. And the High Court at least has given us a level of clarity about how to approach multiplicity. But pause for a minute and consider the doctrine that exists now in this country. The courts, when they're faced with multiple class actions, engage in what is being called a multifactorial approach. It boils down to choosing which of the vehicles has the greatest prospect of returning the most recovery to group members. It is, let me put it pejoratively for a moment, an auction process. And participation in the auction is secured by commencing a class action. And the court presides over the auction, and the participants in the auction put forward their bid on evidence to win carriage of the claim. And the prize is the right to sue the defendant. Now, this is a phenomenon much closer to the growth of what I would call corporate governance breach class actions, as opposed to other very worthy species of class actions in the general product liability or broader social justice realms. The logical premise of this auction type approach is that the court is not imposing penalties for bidding late. The timing of the commencement of the proceedings is not of no real significance to the determination of the carriage motion. And the court is required, and I don't say this critically, to essentially speculate on a range of hypothetical issues, including in regard to each individual class action, the likely magnitude of a settlement or a judgment. When you pause to think about that, that is not a prediction as to the court's function that may have been reasonably made 30 years ago. When Justice Finkelstein thought about this kind of process in Kirby and Centro some years ago, he gave him a significant pause. He wasn't comfortable with the court playing that kind of role. It is historically unfamiliar territory for a court, and a number of judges, even Justice Lee himself, in one sense, the author of this mechanism, has expressed concern with it. In fact, in Get Swift, he said that the court is perceived as a metaphorical auctioneer, and there's something untoward about the court saying, "Are we all done yet? It's now going under the hammer." The court's role is to quell controversies, not to usually to engage in that kind of process. Doctrinal challenge created by the significant growth in class action litigation viewed through a lens of multiplicity. I won't deal with others, but common fund orders are another good example, because they're the High Court in determining that courts do not have power to make a common fund order. You could read between the lines, and sometimes expressly in the High Court's judgment, a tension between wanting to do something that facilitated access to justice, but at the same time being cautious that they weren't seen as adjudicating on a question of whether the class action would be profitable, as opposed to adjudicating on how it most efficiently can be run. Another excellent example of the very interesting doctrinal challenges that are being created by the current state of our class action market. The response to these challenges has not been overwhelming in terms of its intellectual rigour, if I can say that with respect. In the Australian government's response to some of these challenges and their specific response to the Parliamentary Committee's report and the ALRC's report was a document that cut and paste from a lot of different sources. Most of it was a restatement of a debate that's as long as 10 years old. What I found most interesting about that 52-page document was the focus on something called procedural proportionality. Now, this is not a topic that's been, in fact, it's fair to say the government's response hasn't really been picked up in popular discourse, and certainly not in the media, if you exclude the proposed legislation. But their general discussion of reform has not been considered interesting. The procedural proportionality topic, though, is interesting. They recommended, similarly to the Parliamentary Committee, that class action, the proportionality of the class action process and the costs versus the return should once again come under the microscope, and that there should be legislative change to achieve that. They have not articulated much about what that legislative change should be. The new legislation that we've discussed already today doesn't deal directly with that question of proportionality, except in the somewhat blunt way of identifying a benchmark for recovery to group members versus those that promote them, but it doesn't deal with the efficiency of the process to get to that point. This is not a hypothetical question that people like myself like to talk about to make themselves feel important. It's real within the case law and in the jurisprudence that we are all grappling with questions of proportionality. Justice Murphy, when he 3 years ago considered the settlement of the Peterson and Bank of Queensland litigation, he concluded in that case that the law firm with carriage of that proceeding on behalf of the class, that their costs were, quote, plainly disproportionate to what could reasonably be expected to be achieved in the litigation. In that criticism, he turned to a broader observation about a problem in class actions, which articulates exactly against the issues I'm trying to describe, where the quantum of the legal costs and funding charges are disproportionate to the recoveries by class members. And he said that occurs in cases where one or more of the following characteristics arise. Damages are less than $30 million. Settlement isn't achieved until late in the case. The liability case is not strong and it's strenuously defended. There are multiple respondents, and perhaps most pejoratively, the applicant's lawyers are insufficiently experienced or cautious for a case of that size and complexity. He didn't say that was the majority of cases, but he did say it was a growing problem. We have not seen effective reforms in our market yet designed to address that issue. Some of the reforms, the motivations are pure, others might be described as political. A possible reform in this space is to consider the introduction of an efficiency hearing for class actions at the start of the proceedings. This would not be a certification process. It would be a hearing directly articulated on the question of what is the most efficient means of running the case, and to front load arguments that may make the interlocutory process more efficient and less costly. Prior to the efficiency hearing, the parties could put forward material, including some outlines of expert evidence that they anticipate addressing on questions of quantum. In the context of a shareholder class action, for example, an early view on what the materiality of the non-disclosures and therefore the quantum of the case is anticipated to be, perhaps even in a without prejudice environment that no one's going to be held to. And then questions of whether the statement of claim discloses a cause of action that's going to be pursuable in a way that's proportionate to that recovery can be properly assessed. And so can the question of whether the costs are likely to overwhelm the realistic prospect of recovery. If we could front load some of those questions, which are of course unable to be known with perfection at the start of the case, we may make inroads into what is becoming a fairly tragic problem with class action litigation in this country, which is that there are 4 or 5 year proposition to get to the doorstep of a trial, at which time either the proceeding settles or it proceeds to trial in circumstances where maybe the ultimate recovery is disproportionately low compared to the effort to get to that point. But lastly, I'd like to just say a comment about the proposed new legislation, the 70% rule. It is, in one sense, an example of what Justice Lee would call the whack-a-mole problem. You try to solve one issue and you create another. Two aspects that I wanted to leave you with. The first is there is an apparent desire to introduce a level of this proportionality consideration into the assessment of whether a settlement is fair and reasonable. And there's an attempt in the articulation of the criteria that a court must have regard to in approving recovery under a funded proceeding to talk about questions of proportionality. The first 2 criteria are deal with questions of what are the legal costs incurred by the funder and are they reasonable, and have the proceedings been managed in the best interests of members. So while it's arguable that those are already embedded in the common law notions of fairness and reasonableness under 33B of the Act, it is interesting to see them being given some express life. But the more interesting and I think unintentional aspects of this legislation, and I speak now from a defendant's perspective, are there unintended consequences, arguably. The requirement that funded litigation essentially must be closed because the court must approve the funding agreement and the funding agreement must have the express signature or opt-in of every member is interesting and possibly problematic, because to the extent that it incentivizes closed classes to be commenced as opposed to open classes, as Professor Spender has indicated, that is a problem for both finality and also the triggering of tail risk for defendants who prefer to settle proceedings once and for all, or prefer to have a trial that deals with the controversy once and for all. There's another issue, hidden, I think, which is that the 70% rule may create interesting practical dilemmas. Assume a settlement, I'll end on this point, could have in the past be achieved for a payment of $50 million. Assume that comprised, these are not uncommon numbers, $10 million of plaintiff's legal costs and another $10 million of funders' commission. This is purely hypothetical, leaving $30 million to be distributed to group members. By the time of the mediation, which may be on the doorstep of trial, the majority of those legal costs are sunk, and the funder may have some relatively firm expectations of the recovery that they would need to ensure that that exercise has been sufficiently profitable. That settlement that I've just described is presumptively unfair under the new legislation. And accordingly, will the presumption mean that that proceeding now couldn't settle for 50 million, it has to settle for 67 million to do the maths on the 70% rule? And is that sort of outcome in the interests of defendants? Does it handcuff to a degree, although it's only a presumption, the court in taking into account all of the circumstances of the case before it approves the settlement. It'll take time for the jurisprudence to develop if this becomes law, but it does give rise to increased settlement uncertainty in the short term, on top of the uncertainty associated with finality to which I've already referred. This is anathema from a defendant's perspective. It's contrary to principles of quelling the controversy once and for all. And it's possibly an example of trying to solve one problem, but creating arguably a bigger one. I see the time, Dr. Duffy, so I'll pause there.
Many thanks, Jason. Lots of food for thought there. Again, any questions we'll deal with at the end. There's not that many come up yet, so if you've got a question, feel free to start typing. Now, our third speaker is Julian Schimmel, who's a principal lawyer at Maurice Blackburn Lawyers in Sydney. Julian's currently working on Volkswagen, Audi and Skoda class actions on behalf of consumers arising from the Dieselgate emissions issue. Julian has a very broad experience across different areas of class actions, with particular expertise in complex product liability areas. He conducted the ASR hip implants class action, which was Australia's largest product liability class action, settling in March 2016 for $250 million. He's also worked on several large shareholder class actions, including AWB and Oz Minerals, and the cartel class action, competition law class action against Amcor and Visy. Julian also initiated and worked on a class action against the New South Wales government over false imprisonment of children by police, which later settled and resulted in compensation being paid to many of those children. So welcome, Julian. Thanks for attending, and please proceed.
Thanks very much, Michael, for the introduction, and thanks to Monash University for having me along today. Thanks also to Professor Spender and to Mr. Betts for their presentations. What I was going to do is speak about three particular legal and regulatory changes, and to consider the access to justice implications of those changes, or at least as we see them. Before going into the detail of those, just some general introductory comments about the process that got us to this point. And in particular, it was quite striking seeing the slide that Professor Spender put up, listing all of the various reports and inquiries and other things that have been going on. It was, I agree with Professor Spender's comment that the ALRC report should be exempted from some of the comments that were made, particularly that in relation to the sort of churn, rushed and ideologically motivated processes. The ALRC inquiry, which the report was published in December 2018, some 3 years ago, it was a very comprehensive, carefully considered process conducted by an independent body, which made, I think, a really significant suite of recommendations that they're all very well considered and principled. Not everyone would agree with all of the recommendations that were made, but one thing you can say about the process is that it was very well reasoned, very well principled process. And it's a great shame, in my view, that it took 3 years for the government to respond to that report. And even when the government did respond to that report, many of the recommendations were largely ignored and simply noted, and nothing really said about what would be done in relation to them. In the intervening 3-year process, while the ALRC report was effectively ignored, what we've seen is the government pursue a very partisan, politicised process, whereby a parliamentary joint committee considered essentially the same issues or a very similar array of issues that the Australian Law Reform Commission considered, prepared a report which had somewhat different findings and recommendations, and written obviously by politicians rather than by an independent law reform commissioner. And it's really that Parliamentary Joint Committee report, or the report of the majority of the Parliamentary Joint Committee, which seems to be driving the government's policy agenda in relation to class actions at the moment. And so we're here today to speak obviously about access to justice, and the very reason why we have class actions, why they were introduced 29 years ago, is to promote access to justice. And it seems that the government's policy agenda really is the opposite. It's a sort of barriers to justice policy agenda that seems to be pursued at the moment. And particularly in relation to litigation funding, some of the litigation funding reforms, it seems to me that we've seen the government wheel in a sort of Trojan horse of class actions policy. On the one hand, the Parliamentary Joint Committee in its report acknowledges the social utility of litigation funding, the value of litigation funding in the class actions context in particular, in facilitating meritorious claims and then enabling them to proceed. So we have that on the one hand, and the reforms really are justified by reference to the interests of class members. But at the end of the day, the real sort of underlying agenda seems to be to reduce the availability of litigation funding by making it harder for litigation funders to fund cases, and by making class actions less viable and less attractive to funders. And the first sort of example of that, and the first of the three topics that I wanted to discuss, is the regulation of litigation funders, or litigation funding arrangements, I should say, as managed investment schemes. Those, as many of you will know, those changes came into effect on the 22nd of August last year, so about 14 months ago. And really, as I see it, that's a, and Professor Spender alluded to this in her presentation, it's really a sort of square peg, round hole way of regulating litigation funding. I don't think anyone ever, when the managed investment scheme provisions were introduced into the Corporations Act, I don't think anyone ever imagined that they would be applied to the regulation of litigation funding arrangements. Even ASIC is on the record as saying that the managed investment scheme regime is ill-adapted to the regulation of third-party litigation funding. The access to justice impact is pretty straightforward, and I think it's one that, in fact, that we're already seeing when we consider some of the recent empirical data, which I'll come to in a moment. And the main access to justice impact is that that those regulations are likely to have an impact on, or rather are likely to lead to a contraction of the funding market. When the ALRC published its report, it noted that there was somewhere north of around 30 litigation funders who are active in the Australian market. And it's hard to imagine that the new regulations that came into effect in August last year aren't going to act as a disincentive to many funders due to the regulatory burden, compliance costs, the requirement to get an AFSL, publish product disclosure statements, appoint a responsible entity, and all of those sorts of things. And so although it is still early days, only some 14 months or so since those changes were introduced, I think we are already seeing an effect. And I mean, Jason referred to some empirical data earlier. It has been a busy 12 months for class action filings generally, but if we look specifically at funded cases that have been commenced since the 1st of July last year, the 1st of July 2020, there has been those 12 months, the 2021 financial year, have seen the lowest proportion of funded cases for about 7 or 8 years, since 2013, 2014. Only 38% of class actions filed in that time were funded. And critically, since August 2020, when those changes came into effect, there's only been 7 funded class actions that have been filed. So that's 19 of the 19%, I should say, of the class actions that were filed. And if you look to some of the previous years, as Jason alluded to, the proportion of funded cases were, 50%, 60%, even in some cases 70% of all class actions involved litigation funders. So I think it is early days. Time will tell whether that sort of dip in the proportion of funded cases is sort of the industry kind of taking time to adjust and rebalance to the new regulatory environment, or maybe it's a reflection of other factors that are impacting on the rate of new filings, particularly for funded class actions, or is it the start of a longer term impact where we're going to see a much lower proportion of cases proceeding with litigation funding? And I mean, one of the reasons why there is that access to justice impact really is that it can't be assumed that that gap in funded cases will necessarily be filled by class actions being run on a no win, no fee basis, which is obviously the other predominant funding model that we see in relation to class actions. So the next, and this has already been touched on, the next topic is the 70% bill, as we've been calling it. So this has superficial appeal, I would say. I mean, who doesn't want to see more money flowing into the pockets of claimants and plaintiffs in class actions? Certainly, as a plaintiff lawyer, that that's what I want to see: as much compensation, as much money flowing into the pockets of the people who are class members in these cases. On the other hand, there are access to justice implications from that bill, or there would be access to justice implications from that bill. The first, again, is the availability of funding. So it's likely to contract the pool of cases that a funder would consider to be viable to fund, and gives rise to risks that litigation funders may simply be unwilling to assume when they're considering whether or not to fund a case. And I think Jason illustrated that quite well in the hypothetical settlement scenario that he talked about, and the sort of potential impact on the sort of practical aspects of how cases are run. And I mean, the reason why it may be unviable for class actions or many class actions to continue to be run on a funded basis is that, I mean, there's simply, in a lot of cases, and including some of the ones that Justice Murphy, the types of cases that Justice Murphy referred to in the Bank of Queensland case, there simply won't be room for both lawyers to be paid reasonable legal costs, and also for a litigation funder to receive remuneration for the services that it provides. And again, assuming that the void that is left by litigation funders being unwilling to assume these types of risks, that void, you can't assume that that's going to be filled by plaintiff law firms undertaking to run cases on a conditional fee basis. The other access to justice implication, again, this has been touched on already, but the likelihood that we'll see more closed classes. The Australian Law Reform Commission in its report recommended that all class actions should be commenced on an open class basis, and principally for access to justice reasons. And it seems to me that the 70% bill will run directly contrary to that, and is likely to lead to more cases being, and to the extent that cases continue to be run with litigation funding, it's really essentially runs contrary to the opt-out model that Part 4A is premised on, and the other state-based cognate state regimes are premised on. So, and as has already been alluded to as well, potential constitutional problems likely to give rise to increased interlocutory activity, resulting in more costs, more delay, and more cost and delay also flowing from other aspects of the bill as well. Just its very introduction is likely to spawn a whole raft of interlocutory disputation that I don't think is in the interest of class members in these cases. There's also, in the 70% bill, there's a sort of inherent unfairness that is built into it, because in considering whether the presumption, the 70% presumption should be rebutted, the courts, by being given an exhaustive and limited list of criteria that the courts are allowed to consider, the courts aren't in fact allowed to consider the one factor that I would say is one of the most important in considering this proportionality question, and that is, how do the returns to class members compare to their best case recovery? Put simply, when we're considering the application of a percentage, we're using the wrong denominator in the equation. And there's a real world example of that. So the recent judgment of Justice Beach in Evans and Devantage Group, where group members received only around 37 or 38% of the gross settlement sum, and yet it was noted that that they would receive approximately 100% of their losses. So that's sort of a consideration where you have, albeit in circumstances where a significant part of the settlement sum is being used to pay lawyers and a litigation funder, class members did very well in that case, receiving 100% of their losses. That sort of a situation would fall foul of the 70% bill. And it seems to me that the courts wouldn't be able to take that sort of a consideration into account in deciding whether or not to depart from the statutory presumption. So the final thing is the final topic is the changes to the continuous disclosure obligations. Those changes come into effect it came into effect, I should say, in August this year. Still very early days. I'm not aware of any shareholder class actions having been filed since those changes came into effect. Just the sort of brief summary of what the changes are. There's a change from a purely objective standard in considering the circumstances in which the disclosure needs to be made. An objective standard that requires disclosure of information that a reasonable person would expect to have a material effect on the share price, to introduce a false element into that provision. So information that the entity knows or is reckless or negligent as to whether the information would have a material effect on the share price. And the changes is also, as I'm sure many of you know, extends to the misleading or deceptive conduct provisions in the Corporations Act as well. So even though negligence is included as one of the ways that the mental element might be established, that the access to justice implication that I see in all of that is in shareholder cases that in the past have related to accounting misstatements. The new laws, I think, will allow a company to argue that it should not be liable, and in particular that it was not negligent because it relied on the advice of an auditor. Claims against an auditor in those sort of circumstances would be difficult to bring, because if the company is not liable, it will be difficult to argue that the auditors were involved in a contravention. So really the upshot is that the effect of the changes to the continuous disclosure laws are likely to leave shareholders without a remedy in some circumstances where in the past they have had remedies. So those are the three topics that I wanted to explore today. Three recent changes to laws and regulations affecting class actions, and each of them in my view, having a striking impact on access to justice. Thanks,
Julian. And we'll do some questions in a minute, but just again, thank you to all our speakers for some, as I say, lots of food for thought and some very good insights into the area. Now we don't have that many questions, but we've got one. The first one is actually it's addressed to Professor Spender, but anyone else who wants to have a go thereafter can do so as well. So the question is to Professor Spender, could you please explain briefly the potential constitutional issues in relation to the 70% proposal, as these don't seem to have received much media coverage, or what they might be, or what they are, and do they have legs, I guess?
Yeah. So I was first alerted to this when Justin Gleeson mentioned it in a seminar for AAL, and it's been referred to in some of the submissions to the PJC inquiry. So it is, when I first heard it, I thought maybe, but I just preface these comments by saying I'm not a constitutional lawyer, so you do get a bit of osmotic constitutional law when you're situated at ANU, but that's as far as I could go. But there's some things about the bill that are very, to me, are a bit unusual in terms of its constitutionality. The first thing is the provision which says what the court must take into account. It says when it's making an order to approve we'll call it a settlement. And it says it must have regard only to the following factors, and it lists the factors. So that's a slightly unusual provision when it's directed at judicial discretion. It's not, of course, unusual when it's directed to administrative discretion, but it's unusual. So regard only, particularly where there's a provision alongside that provision, which is section 33V, which lists the things that the court must take into account when they're approving a settlement. So there's some strange combinations of things in play. So that raises chapter 3 questions. And my sense about chapter 3 jurisprudence is that it's very vigorous. It's very vigorous, and particularly the question about restraint of judicial power is quite important. But there's a lot more than this. What the bill purports to do is extend its provisions to the state and territory courts. Okay, I think this is the real kicker, because and if you look at I think it's 601 LF, it's some provision around there that says that it extends, the provisions extend to the state and territory courts if they're exercising federal jurisdiction. Now, there's nothing unusual about that, because, as you know, federal causes of action are commonly interwoven in class actions proceedings. So it's purporting to expand those provisions. Now, we know that the federal government shoves a lot of things into the Corporations Act. That's why the ALRC has a reference at the moment in relation to Chapter 7. It's a common, well, it might be slightly disparaging to say this, but it's a slight bit of a dumping ground because of the extent of Section 5120 of the Constitution. It's potentially a big source of federal power. So what they're doing is putting this into the Corporations Act, but they're purporting to apply it to state and territory courts. And the problem with that is, again, it raises, Chapter 3. It raises the Melbourne Corporation Principle, which I frankly know I know almost nothing about. But it also raises that question about the Corporations Act being predicated on a state referral of power. And this is, I think, where it becomes really quite interesting, because if you've got provisions like the group costs orders in Victoria, you've got disparate provisions, you've got the feds purporting to override a provision which is clearly predicated on a state exercise of power. I think in combination, you've got some pretty interesting and potentially persuasive arguments about its constitutionality. So that's my comments. Perhaps the other speakers might be interested in saying something about it.
Anyone else want to say anything about that issue?
I agree with those comments. I'd only be repeating. I do think there's an issue about whether, even at taking the state dimension out of it, just at the federal level, whether the corporation's power could support all of that bill. But I equally don't want to go beyond my specialism.
It's a very interesting issue, and I guess the fact of a referred power, and I think that goes back way back to arguments when the corporations law came in about incorporation of companies, and as everything else, it was a fight about money because the states wanted to keep incorporation because it was a revenue raiser for them and so on. And then of course we had the Wakeam case as well, I think, which was interesting about federal jurisdiction and state jurisdiction and so on. Yeah, it's sort of interesting why that this is all going to be regulated through corporations law when you might think, why isn't it regulated under Federal Court Act or Supreme Court Act in relation to jurisdiction over courts and court process and so on. I think that was my original submission to the VLRC many years ago. But anyway,
just one thing that's not constitutional, but that summarises a little bit of what the other esteemed speakers have said, is there's a question as to whether the efficient way to look at this is whether, okay, I'm going to assess the proportionality of a settlement sum, as opposed to a more nuanced inquiry as to whether that might be twofold. One is, what is the recovery of this funder? What's their return on their investment? I mean, are we comfortable with that? And two, I think picking up Julian's point, is this a fair recovery compared to the value of the group members' claims? Neither of those are easy questions, and they're harder to address in legislation, but they, I think, address the question of proportionality more directly than the somewhat more blunt instrument in the exposure draft.
Yeah, I think that's right. I mean, and the courts already do think about proportionality, and as most people will know, the Federal Court's class sections practice note requires consideration of how returns to the class compare to their best case recovery. So that's the relevant benchmark that should be used to consider proportionality. Not, I mean, the amount of a gross settlement sum that is paid to the class in some ways is not relevant. What is relevant is how class members' returns compare to what they were seeking in the case.
Julian, one thing I'd add to that though is at the other extreme. I think there are cases where, while it's attractive to think that the class action mechanism works for them because the individual claims and recovery are going to be so small, that in fact those individual claims are so small that the cost of any class action litigations are going to overwhelm, or potentially overwhelm, particularly when you add factors like limitations period and the veracity of a defendant's defence and those matters. Now, they're intangibles, hard to assess at the start, but even the ALRC back in '88 said, look, this isn't going to be for, don't think of this as for every kind of claim that can theoretically be aggregated. I think we've seen some settlements work through the system where the proportionality issue is just a proxy for a slightly more nuanced question.
Yeah, look, I'd agree with that in some ways, and particularly that, it's not every group of claims that's going to be suited to the class actions regime. But, I mean, I think what we're talking about here, and just sort of thinking about it from the perspective of what the bill is trying to achieve, I think that's how I'd contextualise my comments.
I might ask a question generally in relation to, I guess, the regulation of class actions as managed investment schemes, which interestingly, I think, sort of didn't come from the legislature originally. It was a legal argument made to a court, and the court accepted that argument originally, and they were found to be managed investment schemes and so on. But it does seem to be that, and there does seem to be a pretty widespread view that it's a somewhat inapt form of regulation of a class action. I'm just wondering, but assuming that, what is the alternative? What, in terms of getting better disclosure to group members, does anyone have any views as to how it should be regulated, if not as a managed investment scheme? Is there anyone have any thoughts on those sorts of issues, I guess, in terms of disclosure, more disclosure to group members and so on. And or does anyone have any views about why it is or is not an inapt form of regulation?
I mean, just to kind of kick things off, I mean, it's not entirely clear to me why it's actually necessary to have this sort of complex overlay of additional regulatory requirements. I mean, we have a funded class action, obviously enough to fund any prospective clients who wish to have the services of a litigation funder. They're going to be given a litigation funding agreement that will already have a substantial amount of disclosure in it. What we now have is under the MIS regulations, a requirement for a product disclosure statement to be published. And in fact, what I wonder is whether there's actually a sort of counterproductive effect here. I've seen the product disclosure statements that have been published by some litigation funders since August last year. They run to kind of 60 or 70 pages long, and particularly, for a sort of retail class member, as we described them earlier, there have to be questions about the sort of accessibility and intelligibility of those sorts of materials given their length. The requirement for an AFSL license, I don't understand why that is necessary as a regulatory requirement to, and the MIS regime, it's designed to protect the interests of investors in managed investment schemes, and class members in class sections as that regime applies to litigation funding arrangements. Why do we need a litigation funder to have an Australian financial services license? I don't really understand.
Sorry, Professor Spender, if you want to go next, I was just going to add a quick comment, which was I support an AFSL requirement if it was tailored to the appropriate concerns. I accept that the MIS machinery is a square peg in a round hole, but the concept that there is a regulator responsible, when millions or billions of dollars are transferred across the economy, if you or I or any of us tried to do that, we would be regulated and we'd have an AFSL. And so I see the value in a regulator responsible for addressing compliance with a license that maybe has requirements for breach reporting and maybe even some prudential requirements. Trouble is the current AFSL regime doesn't really deal with those things that concern me. And so it would need to be retrofitted in that way. So I think at the moment it's a question of possibly there's the philosophy a lot of people are aligned about, even funders, but the implementation needs to be more precise.
Yeah, look, I agree that there's some interesting points about this, because this demonstrates why we really need to go back to TORs. Now, everybody says that all the time about devising laws. We need to really rethink this, but we really do need to rethink it. And the problem, there's a few things. So what we're doing is classically what historians refer to as path dependence. We've got these existing things that are in play that we're trying to squeeze the class action into. Now, dealing with some of those things that we need to squeeze into, with the MIS scheme is predicated on the idea of someone making an investment. Now, you can't really conceptualise the interest that's held by someone who has a claim as an investment. Or if you do, you have to really start thinking back. Now, there's some sort of good, sort of conceptual thinking that's been done in some of the assignability cases about what the nature of the shows in action is when we're talking about a claim that's in a group proceedings. But there's more work that needs to be done. I don't think it was well done in Brookfield. I don't think the High Court did it very well with due respect in ILP. I don't think they fully understood the difference between a financial product and a credit type product. So all of those things need to be rethought from TORs, okay? The other thing about the AFSL, I agree with what Jason just said. I've advocated AFSL because of the concerns about the lack of transparency about the arrangements between funders and lawyers in particular. And the AFSL anticipates, well, it's got particular strategies in play for dealing with conflicts of interest. The problem with it is it's aligned to ASIC. ASIC's already overwhelmed. ASIC doesn't want this extra work. It's already got too much to do. So what we really need is it's different type of thinking again to how to manage those questions about transparency and conflict of interest. So yeah, it's a problem again about past dependency, existing products, exercise of federal power that is making this all a bit, as I said, messy.
Also, perhaps, you know, the political process where we never reverse anything or simplify anything, we just make it more complicated when we reform, and it does seem to be, you know, becoming horrendously complicated.
Yeah.
I don't think we have any other questions, but and we're nearly at 2:30. So if anyone, I'll give the opportunity. Anyone wants to make any final comments?
I had just one, if I may, for 1 minute, which is I have started to see work through the system some class actions that rely on either the temporary relief that was introduced to the continuous disclosure obligations, or more recently the new law. And one interesting question, I don't put this to push back on Julian's assessment, just to sort of raise it, is whether the introduction of the negligence and recklessness safe harbours, if I can call them that, actually make any change. And the reason I say that is in most shareholder class actions, the allegation is that the disclosing entity at least constructively knew that what it was saying to the market was wrong. And there's an interesting question about how close that is to a concept of negligence in any event, or possibly even recklessness. It certainly, my view is, could be pleaded in a way that wouldn't, that the new legislation wouldn't seismically change the practice. It'll probably be more of a question about, in proof, does it create a harder job for plaintiffs or an easier job for defendants?
We'll see how it plays out, I guess. All right. Well, again, I'd like to thank everyone, and thank our distinguished expert speakers. And I think it's been a very productive, interesting session. So thanks again to everyone, and thanks for those who've attended. And we will hopefully see you all again very soon. Thanks, everyone.
Thanks, Michael.
Thank you.